Florida, the Sunshine State, land of beaches, theme parks, and endless summer. But there's another side to Florida that doesn't make it into the tourist brochures, a side where justice isn't blind, where the people sworn to uphold the law are the ones breaking it. We're not talking about criminals today, we're talking about judges, the men and women who sit in courtrooms across Florida, wearing black robes, holding gavels, and deciding the fate of thousands of people every single day. What happens when the person behind the bench is more dangerous than the person standing in front of it? What happens when the guardian of justice becomes its greatest threat? Today, we're going deep into the darkest corners of Florida's judicial system. These aren't stories about bad judgment calls or honest mistakes. These are stories about corruption, abuse of power, and betrayal at the highest levels. These are the judges who sold justice, destroyed lives, and got away with it. This is the story of Florida's darkest judges, and I promise you, it's worse than you think. Case 1. Judge Sharon Lovelace Blackburn. Let's start in Escambia County, way up in the Florida Panhandle, Pensacola area. This is where Judge Sharon Lovelace Blackburn presided over family court for years. Family court is supposed to be different from other courts. It's not about criminals and victims, it's about families. Children, parents fighting for custody, couples going through divorces. These are people at their most vulnerable, their most desperate. And the judge is supposed to be the person who cuts through the emotion and makes decisions based on what's best for the kids. But Judge Blackburn had a different approach. For years, she ran her courtroom like a personal fiefdom. She didn't care about the law. She didn't care about precedent. She didn't care about the families standing before her, begging for fairness. She cared about one thing, her own authority. Parents would come into her courtroom with evidence, medical records showing abuse, police reports documenting domestic violence, testimony from teachers, counselors, and family members. They'd present their cases, following the rules, doing everything right. And Blackburn would ignore it all. She'd make decisions based on her gut feelings, her personal biases, her mood that particular day. If she didn't like the way a mother dressed, that could affect her ruling. If she thought a father was too emotional, she'd hold it against him. The actual facts of the case? Secondary at best. One case that came to light involved a mother fighting desperately to protect her children from an abusive father. The evidence was overwhelming. Hospital records showing injuries to the children, police reports from multiple domestic violence calls, a restraining order that had been violated repeatedly. Child psychologists testified that the children were terrified of their father. Blackburn gave the father custody anyway. Why? Because in her view, the mother was being too dramatic. Because she believed that children need their father, regardless of whether that father was dangerous. Because she could. The mother appealed. She fought. She spent money she didn't have on lawyers, trying to protect her kids. And while the appeals process dragged on, those children were living with their abuser. Because a judge decided that her personal beliefs mattered more than the evidence. That wasn't an isolated incident. Complaints started piling up. Attorneys who practiced in her courtroom began documenting patterns. Parents filed grievances with the Florida bar. Other judges started hearing whispers about what was happening in Blackburn's courtroom. But nothing happened. For years, nothing happened. See, removing a judge is hard, really hard. They have protections that most people don't have. They're appointed or elected to serve terms, and unless they do something egregiously illegal, they're almost untouchable. Eventually, the Florida Judicial Qualifications Commission got involved. They investigated, they interviewed attorneys, reviewed case files, and talked to families who had been through Blackburn's courtroom. And what they found was a pattern of misconduct so severe, so consistent, that they had no choice but to act. Blackburn was publicly reprimanded. She was sanctioned. Her reputation was destroyed. But she kept her job. She stayed on the bench. And all those families she'd hurt, all those children she'd put in danger, they didn't get justice. They didn't get their childhoods back. They just had to live with the consequences of a judge who thought she was above the law. That's the thing about judicial misconduct. By the time someone gets caught, the damage is already done, and there's no way to undo it. Case 2. Judge Fred Moreno. Now let's head south to Miami, Federal Court, the Southern District of Florida. This is big time. Federal judges are appointed for life. They handle the most serious cases: organized crime, drug trafficking, white-collar crime. These are the judges who are supposed to be the best of the best. Judge Fred Moreno was appointed to the federal bench in 1990. For 2 decades, he presided over some of the most high-profile cases in South Florida. He had a reputation: tough, no nonsense. Some people respected him, others feared him. But there was another side to Judge Moreno, a side that eventually got him in serious trouble. In 2011, Moreno was presiding over a massive case involving a Ponzi scheme. We're talking billions of dollars, thousands of victims, the kind of case that makes national news. The defendant was facing serious prison time. The victims were desperate to see justice served. And Moreno was supposed to be the neutral arbiter who made sure everything was done by the book. But Moreno had a problem. He couldn't control his temper. From the beginning of the trial, Moreno went after the defense attorneys. Not tough questioning, not strict enforcement of courtroom rules. We're talking about verbal abuse, humiliation, attacks that had nothing to do with the case and everything to do with his personal feelings. He'd interrupt attorneys mid-sentence. He'd mock their arguments in front of the jury. He'd make sarcastic comments designed to undermine their credibility. He'd raise his voice, lean forward on the bench, and glare at them like they were the ones on trial. One defense attorney later described the experience as being in a hostile work environment. Except it wasn't a workplace, it was a courtroom, and the person creating the hostile environment was the judge. The defense team tried to push through. They filed motions asking Moreno to recuse himself. They argued that his behavior was so extreme that their client couldn't get a fair trial. Moreno denied every motion. He insisted he was being impartial, but the behavior continued, and it got worse. During one particularly heated exchange, Moreno berated a defense attorney so severely that the attorney filed a formal complaint with the 11th Circuit Court of Appeals. The complaint detailed incident after incident of inappropriate behavior: yelling, insults, bias so obvious that it was affecting the trial. The 11th Circuit reviewed the complaint. They looked at the transcripts. They talked to people who had been in the courtroom, and they made a decision that almost never happens in the federal system. They removed Moreno from the case. Think about that. A federal judge appointed for life, with decades of experience, was kicked off a case because his behavior was so bad that it violated the defendant's constitutional right to a fair trial. The case was reassigned to another judge. The trial started over from scratch, and Moreno's reputation was permanently damaged. But here's the thing. He kept his job. Federal judges are appointed for life, remember. Unless they commit a crime or are impeached by Congress, they can't be removed. So Moreno stayed on the bench. He continued to preside over cases. He continued to make decisions that affected people's lives. And the question that nobody could answer was this: how many other cases did he handle where his temper affected the outcome? How many defendants didn't get a fair trial because the judge couldn't control himself? How many attorneys were too afraid to file complaints because they knew they'd have to appear before him again? We'll never know. Because most of the time, judicial misconduct happens behind closed doors. Most of the time, people are too scared to speak up. And by the time someone does, it's too late. Case 3. Judge Wade hopping. Let's talk about conflicts of interest, because that's a huge problem in the Florida judicial system, and nobody illustrates it better than Judge Wade hopping in Tallahassee. Hopping wasn't just a judge. He was a lawyer before he took the bench, a successful lawyer with deep connections to Florida's political and business elite. He knew everyone. He'd worked with everyone. And when he became a judge, those connections didn't just disappear. That's where the problem started. In the legal system, there's a concept called recusal. If a judge has a personal or financial connection to a case, they're supposed to step aside. They're supposed to let another judge handle it. That's how we maintain the integrity of the system. That's how we make sure decisions are based on the law, not on personal relationships. But Hopping didn't believe in recusal, or at least he didn't practice it. Case after case, Hopping presided over matters where he had clear conflicts of interest. He'd handled cases involving attorneys he'd worked with, companies he had financial ties to, political figures he'd supported, or who had supported him. When attorneys raised objections, Hopping would dismiss them. He'd insist that he could be impartial, that his relationships wouldn't affect his judgment, that he could separate his personal connections from his judicial duties. But that's not how it works. The appearance of impropriety is just as damaging as actual impropriety. When people look at a case and see that the judge has a personal stake in the outcome, they lose faith in the system. They stop believing that justice is possible. One case that drew particular scrutiny involved a major development project in Tallahassee. The developer was someone Hopping had done business with in his previous career as a lawyer. They'd worked together on multiple projects. They'd made money together. Now that same developer was in Hopping's courtroom, fighting a legal battle over zoning regulations. Millions of dollars were at stake, and Hopping was the one making the decisions. The opposing party filed a motion for recusal. They laid out the connections. They showed the financial ties. They argued that there was no way Hopping could be impartial. Hopping denied the motion. He stayed on the case, and he ruled in favor of the developer. Was the ruling based on the law? Maybe. But nobody could be sure. Because the conflict of interest tainted everything. Every decision Hopping made in that case was suspect. And the losing party had no recourse. They'd lost. And they'd lost in a courtroom where the judge had a personal connection to their opponent. The Florida bar eventually investigated Hopping. They found multiple instances where he'd failed to recuse himself when he should have. They found that he'd violated ethical rules designed to protect the integrity of the judicial system. He was sanctioned. He was reprimanded. His reputation took a hit, but he kept his position. He continued to serve as a judge. And all those cases he'd presided over, all those decisions he'd made while conflicted, they still stood. The people who lost because of his conflicts of interest didn't get a do-over. They didn't get justice. They just got to live with the consequences. That's the problem with judicial misconduct. It's not just about the judge. It's about all the people whose lives are affected by their decisions. And once those decisions are made, they're almost impossible to undo. Before we go any further, I want to hear from you. Have you ever been in a courtroom and felt like the system was rigged, like the judge had already made up their mind before you even walked in? Drop your story in the comments below. Let's talk about it. Because these stories matter. Your experiences matter. And the more we talk about judicial corruption, the harder it becomes for judges to get away with it. Case 4. Judge John Murphy III, Broward County, Fort Lauderdale area, 2014. This is where Judge John Murphy III completely lost control. Murphy had been on the bench for years. He handled criminal cases mostly, arraignments, bond hearings, preliminary matters. The kind of cases that move fast, where judges have to make quick decisions and keep things moving. But on one particular day in June 2014, everything went wrong. Murphy was in his courtroom handling a routine bond hearing. The defendant was represented by a public defender named Andrew Weinstock. Weinstock was doing his job, arguing that his client's bond should be reduced. Standard stuff. Happens 1,000 times a day in courtrooms across the country. But Murphy didn't like what Weinstock was saying. He didn't like Weinstock's tone. He didn't like being challenged. So he did something that no judge should ever do. He challenged Weinstock to a fight. I'm not exaggerating. I'm not being dramatic. A sitting judge in his courtroom challenged an attorney to a physical fight. The exchange was caught on video. You can watch it yourself. It's been viewed millions of times online. Murphy tells Weinstock that if he wants to fight about it, they can take it outside. Weinstock, probably thinking Murphy is joking, says, "Okay," and Murphy loses it. He takes off his robe, right there in the courtroom. He takes off his robe and starts walking toward Weinstock. He's ready to throw punches. In a courthouse. While he's supposed to be administering justice, security had to step in. Other court personnel had to physically separate them. The whole thing was a complete disaster. And it was all on video. The video went viral. National news picked it up. Late-night talk shows made jokes about it. Murphy became a punchline, the judge who wanted to fist-fight a public defender. But this isn't funny. This is terrifying. Think about what this means. This is a person who holds people's freedom in his hands, Who decides whether someone goes to jail or goes home? Who can sentence people to years in prison? And he can't control his temper enough to avoid trying to fight an attorney in his own courtroom. The Florida Judicial Qualifications Commission investigated. Murphy was removed from the bench temporarily. He underwent anger management counseling. He issued a public apology. And eventually he was allowed to return to his position. He kept his job. He's still a judge. And that's insane. Because this wasn't a momentary lapse in judgment. This was a complete breakdown of the temperament required to be a judge. This was a demonstration that Murphy couldn't handle the basic requirements of his job. But here's what really bothers me. That incident was caught on video. It happened in open court in front of witnesses and it was recorded. So Murphy faced consequences. But how many other times did Murphy lose his temper? How many defendants stood before him and got harsher sentences because he was having a bad day? How many attorneys were too intimidated to properly defend their clients because they were afraid of setting him off? We'll never know, because most of the time there's no video. Most of the time it's just the judge's word against everyone else's, and judges almost always win that fight. Case 5. Judge Cynthia Imperato back to Broward County, because apparently they have a serious problem with judges down there. Judge Cynthia Imperato was appointed to the circuit court in 2013. She handled civil cases mostly. Lawsuits, contract disputes, that kind of thing. Not as dramatic as criminal court, but just as important. People's livelihoods depend on civil court decisions. Businesses succeed or fail based on what happens there. In 2015, Imperato was presiding over a case involving a business dispute. Two companies were fighting over a contract. Millions of dollars were at stake. Both sides had hired expensive lawyers. Both sides had prepared extensive evidence. And from the very beginning it was clear that Imperato had already made up her mind. During the proceedings, she made comments that revealed obvious bias against one of the parties. She'd interrupt their attorney constantly. She'd dismiss their arguments without really listening. She'd make facial expressions, roll her eyes, sigh loudly when they were presenting evidence. That's bad enough. But it got worse. At one point, Imperato made a statement on the record that essentially admitted she'd prejudged the case. She said something along the lines of already knowing how she was going to rule, regardless of what evidence was presented. Think about that. A judge admitting in open court that she'd already decided the outcome before hearing all the evidence, that's not justice. That's not even pretending to be justice. That's just going through the motions. The attorney for the prejudged party immediately objected. They filed a motion asking Imperato to recuse herself. They argued that she demonstrated such clear bias that their client couldn't possibly get a fair hearing. Imperato denied the motion. She insisted she could be impartial, despite having just admitted on the record that she'd already made up her mind. The case proceeded. Imperato ruled exactly the way she'd indicated she would. The losing party appealed, and that's when things got interesting. The appellate court reviewed the case. They read the transcripts. They saw Imperato's comments and they were appalled. They overturned her ruling and sent the case back for a new trial with a different judge. But they didn't stop there. They referred Imperato to the Florida Judicial Qualifications Commission for disciplinary action. The commission investigated. They found that Imperato had violated the Code of Judicial Conduct. She'd failed to maintain impartiality. She'd prejudged a case. She'd denied a party their right to a fair hearing. She was publicly reprimanded. The reprimand is part of her permanent record. Anyone can look it up. But she kept her job. She's still a judge. She's still making decisions that affect people's lives and livelihoods. And here's what keeps me up at night. That case only got overturned because the losing party had the money to appeal. They could afford to hire appellate attorneys. They could afford to fight. But most people can't. Most people lose in court, and that's the end of it. They don't have the resources to appeal. They don't have the money to fight a biased judge. So how many other cases did Imperato prejudge? How many other parties lost because she'd made up her mind before hearing the evidence? How many people got screwed because they couldn't afford to appeal? We'll never know, and that's the real tragedy. Case 6. Judge Mark Mahon, Pinellas County, St. Petersburg, Clearwater area. This is where Judge Mark Mahon presided over county court. County court handles smaller cases, misdemeanors, traffic violations, small claims, the kind of cases that don't make headlines, the kind of cases where people often represent themselves because they can't afford lawyers, and that's where Mahon did his damage. For years, Mahon had a reputation among local attorneys. He was known for being harsh, impatient, quick to anger. But he was especially bad with defendants who couldn't afford representation. If you came into his courtroom without a lawyer, you were in trouble. Mahon would treat you like you were wasting his time. He'd interrupt you when you tried to explain your situation. He'd make sarcastic comments. He'd mock you in front of everyone in the courtroom. One case that came to light involved a defendant who was struggling with mental health issues. The person was trying to explain why they'd missed a court date. They were clearly having difficulty articulating their thoughts. They were confused, anxious, struggling to communicate. A compassionate judge would have recognized what was happening. They would have made sure the person had access to mental health resources. They would have appointed an attorney to help them navigate the system. Mahon ridiculed them. He made jokes about their mental state. He mocked their inability to speak clearly, and then he issued the harshest penalty he could. Attorneys who witnessed this were horrified. Some of them started documenting Mahon's behavior. They'd take notes after appearing in his courtroom. They'd compare stories with other attorneys, and a pattern emerged. Mahon wasn't just having bad days. He wasn't just being strict. He was systematically abusing people who were vulnerable. People who didn't know their rights, people who couldn't fight back. Complaints were filed with the Florida Judicial Qualifications Commission. The commission investigated. They interviewed attorneys, reviewed transcripts, and talked to people who had appeared before Mahon. What they found was disturbing. Mahon had violated the code of judicial conduct repeatedly. He'd failed to treat people with dignity and respect. He'd used his position to humiliate and demean people who were already in crisis. He was sanctioned. He was publicly reprimanded. He was required to undergo additional training on judicial ethics. But he kept his job. He stayed on the bench. And all those people he'd abused, all those defendants he'd mocked and humiliated, they didn't get justice. They didn't get an apology. They just had to live with the trauma of being treated like garbage by someone who was supposed to be impartial. That's the thing about judges who abuse their power. They target the most vulnerable people. The people who don't have lawyers, the people who don't know their rights, the people who are too scared or too poor or too overwhelmed to fight back. And most of the time they get away with it. Because who's going to believe a defendant over a judge? Who's going to take the word of someone with a criminal record over someone wearing a robe? Case 7. Judge Karen Givers, Sarasota County. Judge Karen Givers. This case is about what happens when a judge just stops caring. Givers had a long career on the bench. Decades. She'd handled thousands of cases. By all accounts, she'd been a competent judge for most of her career. But something changed. Maybe it was burnout. Maybe it was personal issues. Maybe she just got tired of following the rules. Whatever the reason, Givers started cutting corners. She'd issue rulings without adequate explanation. She'd make decisions without citing the relevant law. She'd ignore procedural requirements that are designed to protect people's rights. In one case, she issued an order that was so vague, so poorly written, that nobody could figure out what she was actually ordering. The attorneys on both sides filed motions asking for clarification. Givers denied the motions and told them to figure it out themselves. That's not how the legal system works. Judges have to explain their decisions. They have to cite the law they're relying on. They have to make clear what they're ordering and why. That's how we ensure accountability. That's how we make sure judges are following the law and not just making arbitrary decisions. But Givers didn't care. She'd issue contradictory orders. She'd make rulings that directly conflicted with Florida law. And when attorneys objected, she'd threaten them with contempt. One attorney described appearing before Givers as playing a game where the rules changed every day. You never knew what she was going to do. You never knew if she'd follow the law or just make something up. That's terrifying, because people's lives depend on these decisions. Child custody, property rights, freedom. These aren't abstract concepts. These are real consequences that affect real people. The Florida bar started receiving complaints, multiple complaints, from different attorneys, all describing the same pattern of behavior. The Judicial Qualifications Commission investigated. They reviewed case files, they read transcripts, They talked to attorneys who'd appeared before Givers. What they found was a judge who had essentially stopped doing her job properly. She wasn't following the law, she wasn't following procedure, she was just doing whatever she felt like doing. She was reprimanded, she was sanctioned, and shortly after, she retired. But the cases she'd mishandled, those people don't get justice. Some of them tried to appeal, but appeals are expensive and time-consuming. Most people just had to accept that they'd gotten screwed by a judge who didn't care anymore. And here's the scary part. How long was this going on before anyone did anything about it? How many cases did Givers mishandle before the complaints piled up enough for the commission to act? We'll never know, because the system is designed to protect judges, not the people who appear before them. Case 8. Judge John C. Murphy Jeter. Let's go back in time. The 1990s, Dade County, which is now Miami-Dade County. This is where Judge John C. Murphy Jr. sat on the bench. Murphy was a criminal court judge. He handled serious cases, felonies, drug trafficking, violent crimes, the kind of cases where people's freedom hangs in the balance. And Murphy was corrupt. For years, Murphy accepted gifts, favors, and benefits from attorneys who appeared before him. We're not talking about a cup of coffee. We're talking about expensive dinners, trips, cash, things of significant value. And in exchange, those attorneys got favorable treatment in his courtroom. This is corruption in its purest form. When a judge takes something of value from someone who has business before them, that's a bribe. It doesn't matter if it's cash in an envelope or a vacation to the Bahamas. It's all the same. It's selling justice. Murphy was careful. He didn't leave obvious paper trails. He didn't deposit large sums of cash in his bank account. He was smart about it. But he got greedy, and he got sloppy. One attorney who'd been paying Murphy for favorable treatment got arrested on unrelated charges. And when he got arrested, he decided to cooperate with prosecutors. He told them everything. About the payments, about the favors, about how Murphy's courtroom worked. The Florida Judicial Qualifications Commission launched an investigation. They subpoenaed records, they interviewed witnesses, they built a case, and what they found was shocking. Murphy had been taking bribes for years. Multiple attorneys had paid him. Multiple cases had been decided not on the merits, but on who gave the judge the best gift. Murphy was removed from the bench. He was disbarred. His career was over. But think about all the cases he presided over, all the defendants who went to prison because they couldn't afford to bribe the judge, all the defendants who walked free because their attorney knew how to play the game. That's not justice. That's not even close to justice. That's a system that's completely broken. And here's the thing that really bothers me. Murphy only got caught because one of the attorneys he was working with got arrested and decided to cooperate. If that hadn't happened, he'd probably still be on the bench today, still taking bribes, still selling justice to the highest bidder. How many other judges are out there doing the same thing? How many are just smarter about it? How many have figured out how to take bribes without leaving evidence? We don't know, we can't know, because the only ones we catch are the ones who get sloppy. Case 9. Judge Lawrence Corder, back to Broward County. Judge Lawrence Corder. This one's recent, 2019. Corder had been on the bench since 2009. He handled family court cases, divorces, child custody, the kind of cases where emotions run high and people are at their most vulnerable. In 2018, the Judicial Qualifications Commission started receiving complaints about Corder. The complaints alleged that he'd been behaving inappropriately in his courtroom, making improper comments, showing bias, failing to follow proper procedures. The commission launched an investigation. They asked Corder to provide information about his conduct. They asked him specific questions about specific cases, and Corder lied. He made false statements to the commission. He tried to cover up his misconduct. He tried to mislead the people who were investigating him. Think about that for a second. This is a judge, someone who presides over cases where people's freedom, their families, their futures depend on telling the truth. Someone who can hold people in contempt for lying in his courtroom. Someone who lectures defendants about honesty and integrity. And he's lying to the people investigating him. The commission didn't take it lightly. Lying to the Judicial Qualifications Commission is one of the most serious things a judge can do. It's not just misconduct. It's an attempt to obstruct the investigation into misconduct. They expanded their investigation, they dug deeper, and they found more problems. Corder had been engaging in a pattern of inappropriate behavior for years, and when he got caught, instead of owning up to it, he tried to lie his way out. The commission recommended that Corder be removed from the bench. The Florida Supreme Court agreed. Corder was suspended without pay. He resigned before he could be formally removed, but the damage was done. His career was over. His reputation was destroyed. But here's what bothers me. All those cases he presided over, all those families who appeared before him, how many of them got fair hearings? How many of them were affected by his misconduct? And more importantly, how many of them have any recourse? When a judge is removed for misconduct, the cases they presided over don't automatically get reheard. People don't automatically get new trials. They're just stuck with whatever decision the corrupt judge made. That's the system. That's how it works. And it's fundamentally broken. Case 10. Judge Fred Hart. Our final case takes us to Palm Beach County, Judge Fred Hart. And this one's about racism. Hart had been on the bench for years. He handled criminal cases. And by all accounts, he'd been a typical judge. Nothing spectacular, nothing terrible, just a judge doing his job. Until 2017, Hart was presiding over a case. The details of the case aren't as important as what happened during the proceedings. Hart made comments that revealed clear racial bias, not subtle bias, not the kind of bias that you have to read between the lines to see, clear, obvious, undeniable racial bias. The comments were so bad that they made headlines. Local news picked it up. Civil rights organizations got involved. Attorneys filed complaints immediately, because this wasn't just about one case. This was about whether a judge with clear racial bias could be trusted to administer justice fairly to anyone. Think about all the cases Hart had presided over, all the defendants who had stood before him. How many of them were people of color? How many of them got harsher sentences because of his bias? How many of them didn't get fair trials because the judge was racist? The Florida Judicial Qualifications Commission investigated. They reviewed the case, they looked at the comments, and they found that Hart had violated the Code of Judicial Conduct. He was publicly reprimanded. The reprimand specifically cited his racial bias. It's part of his permanent record. But he kept his job. He's still a judge. He's still presiding over cases. He's still making decisions that affect people's lives, and that's insane. Because how can anyone trust a judge who's been found to have racial bias? How can any person of color stand before him and believe they're going to get a fair hearing? They can't. And that's the problem. The thing about bias is that most of the time it's not obvious. Most of the time it's hidden in the decisions, in the sentences, in the rulings that seem reasonable on the surface but are infected with prejudice underneath. Hart got caught because he said the quiet part out loud. He revealed his bias in a way that couldn't be ignored. But how many other times did his bias affect his decisions? How many other defendants suffered because of his prejudice? We'll never know, because most of the time bias is invisible. Most of the time it's just a feeling that something wasn't fair, and feelings don't win appeals. If you've made it this far, thank you for watching. Hit that like button, subscribe to Cold Read Crimes, because we're not done. There are more stories to tell, more corruption to expose, more judges who need to be held accountable. And the only way that happens is if we keep talking about it. If we keep shining a light on the darkness in our justice system. 10 judges, 10 cases of corruption, abuse, and betrayal. 10 examples of what happens when the people sworn to uphold justice become its greatest threat. But here's the thing, these are just the ones we know about. These are the judges who got caught, the ones who were sloppy enough or blatant enough or unlucky enough to face consequences. How many more are out there? How many judges are sitting on benches right now making decisions that affect people's lives, and they're corrupt, they're biased, they're abusing their power? We don't know. We can't know, because the system is designed to protect judges, not the people who appear before them. Removing a judge is incredibly difficult. They have protections that most people don't have. They're appointed or elected to serve terms, and unless they do something egregiously illegal, they're almost untouchable. Even when they get caught, the consequences are minimal. A reprimand, a suspension, maybe they lose their job. But they don't go to prison. They don't face the kind of consequences that regular people face when they break the law. And all the people whose lives they destroyed, all the defendants who got unfair sentences, all the families who were torn apart, all the people who lost everything because a judge was corrupt or biased or just didn't care. They don't get justice, they don't get their lives back. They just have to live with the consequences. That's the reality of judicial corruption. It's not just about the judges, it's about all the people whose lives are affected by their decisions. And once those decisions are made, they're almost impossible to undo. So what do we do about it? How do we fix a system that's this broken? I don't have all the answers. But I know that the first step is awareness. We have to talk about this. We have to shine a light on judicial corruption. We have to make it impossible for judges to hide behind their robes, because justice is supposed to be blind. But in Florida, it seems like justice is just looking the other way. This is Cold Read Crimes. Stay vigilant, stay informed, and never stop demanding accountability. Because if we don't hold these judges accountable, nobody will.